How lawyers can use AI to find your assets. That's what they're teaching in law schools right now. They're teaching it in continuing legal education courses that lawyers have to take every year. And if a lawyer could scan your life in minutes, your banking, your business, your real estate, even those old PDFs that you forgot existed, would it decide whether you're worth suing? It would, if you're not protected. So today, I'll show you how to make that AI give up and how to make it work for you. So stay with me because you'll learn the exact ways AI hunts assets, open source intelligence or OSINT, e-discovery, social graphs, and how to structure your plan so those same tools can't hurt you. I'm Kevin, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. We've set up more Cook Islands trusts than any firm in the world. And when you're ready for experienced help, feel free to visit us at assetprotectionplanners.com. You can visit our law firm site at lawyerslimited.com. And if you find value here, subscribe now so you never miss a protection tactic you'd wish that you'd known sooner. I'll be blunt. Lawsuits are an information war. 10 years ago, information moved like a bicycle. Today, with AI, it's a bullet train. Plaintiffs' firms use large language models, LLMs, graph algorithms, and document review bots to answer one question fast. Are you collectible? And if yes, you're a priority target. If no, they move on. So here's the quiet truth. AI doesn't magically break the law. It just accelerates what the law already allows. It speeds discovery, correlates public records, and surfaces inconsistencies. And if your plan relies on no one will connect the dots, AI's job is to connect dots for breakfast. But, and this is the heartbeat of today's episode, legal structure beats search speed. A well-designed structure doesn't hide, it hardens. Now we'll get there. First, see the offense so you can design the defense. Now let's first walk through the most common AI-assisted plays your opponent uses. Number one, OSINT, the open source dragnet. Open source intelligence means public or semi-public data, property records, UCC1 filings, corporate registries, litigation databases, social media, boat and aircraft registries, charity boards, even old PDF newsletters that you forgot existed. AI twist, LLMs now parse inconsistent formats, scanned deeds, crooked PDFs, typos, and unify them into a neat profile, entities you control, addresses that you use, reoccurring counterparties, and where equity might live. So your counteroffer is titling, compartmentalization, and liens that change the collectible picture. So even if they see the asset, the equity they can touch isn't there. Number two, discovery at hyperspeed. Now, opposing counsel will demand emails, contracts, bank statements, text logs. Now, that used to drown teams in cost. Now, AI tools summarize threads, flag anomalies, and surface the smoking gun language or sloppy internal emails. Your counter AI move? Document hygiene. More on that later. Consistency between agreements and operations, and privileged lanes for sensitive strategy documents. So don't create loose ends that you wouldn't want summarized in one click. Next up, social graphs and lifestyle correlations. Now, AI maps people, companies, addresses, and payments into a node graph. So it sees your property manager is also your cousin who forwards rent to a joint account. It spots the LLC that owns your yacht but lists your home for the billing address and the marina under your personal Evernote. Your counter AI move? Clean separation. Business address doesn't equal home address. Corporate contact doesn't equal personal contact. Vendor routing is consistent with structure, not convenience. Number four, predictive worth suing scoring. AI estimates recovery odds. Are there still properties with low liens, consolidated accounts, patterns in deal memos that scream personal guarantees? If you score high, they grind forward. Your counter move, that's what we do. Intentional equity stripping with properly drafted liens. Layered entities so any single target looks dry. The asset protection trusts that put enforcement out of reach of a domestic judge. Now here's the structure that AI can't beat, because law is better than lookup. I've been in the asset protection field for 34 years, and I've been setting up Cook Islands trusts for nearly 30 years. Trends come and go. What lasts is jurisdiction and enforceability. AI can't hack the government law of a trust located outside the reach of U.S. courts. So the core is the Cook Islands Trust and the Cook Islands LLC. So here's the battle-tested framework that we use for high net worth clients. Cook Islands Asset Protection Trust settle offshore under Cook Islands law. Cook Islands LLC owned by the trust. Licensed bonded offshore trustee company law firm, ours, steps in only when a lawsuit strikes and only to do what the trust says, protect you. Okay, here's why this beats AI. Now, AI finds facts. It can't convert findings into enforceable orders against an independent trustee in a jurisdiction that doesn't recognize foreign judgments. The structure is legal and resilient because it's built on conflict of laws reality and not secrecy. When a domestic court says, bring the assets back, you point to a trustee company that's not under the court's authority. So that's not hiding. That's legal separation of powers between jurisdictions. Okay, next up, real estate equity stripping beats a disappearing act. We don't vanish your U.S. real estate. We don't pick it up and move it. Judges hate that, and so do lenders. Instead, we strip the equity by placing properly drafted mortgages or liens in favor initially of your Cook Islands LLC that's owned by your trust. When pressure rises, we can sell those notes to a third-party lender and deposit the proceeds offshore. Now, even if AI sees the house, the collectible equity is gone. Lawsuit math changes. Now, your operating company should not be your wealth warehouse. Use a domestic LLC for operations. Then use separate holding entities for safer assets. We quarantine the risk. AI can map what's together. It can't easily pierce what the law compartmentalizes. Okay, now what's the innocent thing that gets people sued? That's a big question. Here's a twist. It's not always the big house or the yacht that paints a target. Often it's a casual email or old LLC filing that signals you're disorganized and easy to pressure. Plaintiff's AI loves messy people. In a minute, I'll show you 5 AI-hardened habits that make you look boring to sue, even if you own plenty. But first, you need to understand how AI reads your story. Number 1, narratives, not just data. Modern models don't just list facts. They build a narrative of control and benefit. They infer who's the real boss of each asset. If your documents say one thing, but your emails say another, yeah, that's basically mine. AI flags it. That inconsistency becomes the pry bar. Action: your documents, behavior, and communications must harmonize with your structure. If your trust owns it, you shouldn't talk as if you personally own it. Number 2, time-stamped weakness. Now, AI looks for timing. Big transfers right before litigation. Liens recorded the day after a demand letter. That smells like a fraudulent transfer claim. Action: proactive setup beats reactive scrambling. The best time is now, not after trouble starts. You'll thank me for that advice later. Number 3, signature and metadata forensics. Even if you scan and re-sign, PDFs carry metadata. AI compares versions, timestamps, and who authored what. Action: work with professionals who manage document versioning and privilege property. Don't DIY high-stakes paper trails. Now here's 5 AI-hardened habits for the ultra-protected. Habit number 1, compartmentalize like it's your job. Different LLCs for different risk pools. Separate banking, distinct addresses and signers. AI can map connections, but it can't make a court ignore lawful separations that are cleanly run. Example, real estate portfolio in land trusts. We set up thousands of land trusts for privacy of title with liens payable to the Cook Islands LLC. The operating company rents from your holding company over here that holds the assets. So the company that's vulnerable, that's liable, that operates and collects money from customers and does the work, holds little to nothing. Your holding company over here holds the assets that it uses, and it pays lease payments to the holding company. So when this one gets sued, there's really little to nothing to take. And each lane has its own documentation. Habit number 2, paper the reality. If structure says trust owns, manager manages, your emails and invoices should reflect exactly that. No sloppy my house, my account talk when it's trust property held via an LLC. Precision prevents AI from crafting an alternate story. Habit number 3, equity stripping early. Record liens before there's even a whiff of litigation. AI will notice timing. You want your file to say, this was strategic corporate finance, not a reactionary shield. Habit number 4, document hygiene. Short, factual, professional. Avoid sarcasm and jokes about hiding assets. AI will not get your sense of humor. Avoid personal guarantees unless they're avoidable and properly hedged. Habit number 5, privilege pathways. Keep legal strategy inside attorney-client and work product channels. Your planning memos should travel through counsel, not Slack. AI can summarize chat logs that you didn't intend to share. Okay, here's cliffhanger number 2, the hidden leak that professionals miss. Most professionals guard the big stuff, trusts, LLCs, liens. What leaks? Patterns, Venmo descriptions, recurring appointment locations, subscription addresses, image metadata on photos of the new vacation home. AI mines the patterns. In only 2 minutes, I'll show you the privacy hygiene checklist that we give to ultra high net worth clients so their patterns don't betray their plan. Okay, here's how to turn AI into your bodyguard, and this is how to make it work for you. AI is not just for the other side. Used correctly, it makes your defense sharper. First of all, pre-litigation vulnerability scan. Now, they're going to do this on you anyway, so you can do it on yourself first. Run a quick internal OSINT, that's open source intelligence sweep, on yourself, and you do this by searching your own name, company names, addresses, phone numbers, and emails across Google, public property, and court databases, social media, and data broker sites. And then review what's publicly visible and remove or correct anything sensitive or outdated. In short, Google yourself like the opposing lawyer would, but also use ChatGPT. That's chatgpt.com, as you probably know. And then Gemini, that's Gemini, Gemini.google.com to search yourself. And then see what comes up. And then make sure to lock it down before they do. Number 2, AI-assisted consistency audit. So feed your agreements and operating procedures, privilege channel, into an internal model by uploading those documents into ChatGPT and ask it to flag inconsistencies. Things like manager roles, ownership statements, rent terms, lien references, and then fix mismatches now. Number 3, document classifier and auto redaction. So use tools that auto classify and redact personal addresses, account numbers, and signatures in production sets. The less you produce, the less you give them to pivot on. Number 4, timeline builder. Before discovery, build your own AI timeline of transactions, liens, and trust actions. If there's a story to tell the court, tell it cleanly, and don't let the other side's model write your narrative first. Okay, next up, the privacy hygiene checklist. This is the executive version for you. Accounts and addressing. No personal addresses on entity bills. Use office or registered agent addresses consistently. That's what we provide, registered agent services around the country and around the world. Payments. The business pays business expenses. The personal pays personal expenses. Memo lines are factual. September rent. Never cute yacht fuel. Photos and metadata. Disable geotags on social. Be mindful of background details. Dock numbers. Street signs. Reflection reveals. Next up, cloud folder. Separate legal strategy into a privileged folder with counsel. No personal musings mixed with board minutes. Subscriptions and shippings. Use entity cards and addresses for entity property. Communications. Assume anything in regular email could be summarized against you, so keep sensitive strategy discussions with counsel. Real estate. Title privacy with land trust. Like I say, we set up thousands of land trusts. You put them in the land trust where appropriate. Liens to your Cook Islands LLC initially. And we also have third-party lenders who will purchase those liens and put the proceeds into your offshore trust. Clear lease agreements if an OpCo uses the property. Vehicles, boats, and aviation. Title in appropriate LLCs. Ensure operating agreements match insurance and marina hangar docks. Legacy PDFs. Now review old filings and marketing material that accidentally overpromise personal control. So clean up what's public. Calendar and location. Many apps leak patterns, so turn off sharing if you don't need it. Okay, cliffhanger number 3, but what about divorce? Now, divorce lawyers are among the most aggressive users of AI pattern matching today. They trace lifestyle, gifts, reimbursements, and helpful parent loans that look a lot like equity trails. So here's what they can't do. Force an offshore trustee in a foreign jurisdiction to obey a domestic court. So in a moment, I'll explain how to prepare for marriage or well before a divorce filing and how timing and intent really matter. First, a quick reality check. Here's the key point. Timing is everything. Asset protection is not a hide it Friday, file it Monday thing. Courts look at intent. So move early while the seas are calm. Fund your trust as part of a normal, prudent wealth plan. Okay, here's your firewall mechanics. It's going to protect your money from lawsuits. Your Cook Islands Trust owns the Cook Islands LLC. You manage the LLC in normal times. When a domestic court orders you to repatriate or bring back the assets, the independent licensed trustee company law firm must decline if doing so would harm the beneficiary under Cook Islands law. So now your compliance shifts from do what a judge says to comply with your trust deed and Cook Islands law. So that's your firewall. Okay, here's what you keep doing domestically. You still operate your business. You bank domestically as needed to pay your payroll and so on. And you own real estate, but with liens and compartments that make AI's recovery score unexciting. We record UCC1 lien against your business and all of its assets, so it makes that not exciting. Plaintiffs invest where returns look good, so we make your profile look like kale to a toddler. I mean, technically food, but nobody wants it. Okay, next up, case studies. Let's talk about real situations with real people and what happened. First of all, case study A, the physician with rentals. Net worth of this physician, $7.5 million. He owned 14 rentals in his personal name across 3 states. So he looked like a piñata. So we moved titles of the individual properties into separate land trusts for privacy. We made LLCs the beneficiaries of each land trust. And then we layered liens, initially payable to a Cook Islands trust. So we created the proper leases between the operating company and the properties and settled a Cook Islands trust. A claimant's OSINT flagged properties, but after liens, AI recovery estimates fell. So they settled for nuisance value. Okay, case study B, the manufacturer with PG exposure. A business owner with several personal guarantees on equipment. We restructured the vendor contracts, placed cash flow assets into a separate holding LLC, and we moved reserves into an offshore account owned by the Cook Islands LLC that's inside the trust. When a supplier buffed with litigation, their counsel's AI saw the firewall in compartments. They negotiated rationally instead of going nuclear. Case study C, the mid-divorce entrepreneur. Now, we couldn't move certain assets due to timing and court orders, but we could strip the equity in real estate via third-party notes and tighten privileged channels. Result? Lower perceived collectability, faster settlement, lower fishing expeditions. Now, here's what AI still can't do and how to keep it that way. AI can't change jurisdiction. AI can't compel trustees outside a court's reach. AI can't defeat liens that are real, seasoned, and documented. AI can't fix your sloppy paper trail, only expose it. So your job is simple. Build the structure, trust, LLC, liens, paper it cleanly, and behave consistently. Our job is to design and maintain that structure for clients all around the country and around the world, so that if AI looks your way, it shrugs. Okay, here's the subtle art of boring to sue. Plaintiff's AI profiles hundreds of potential defendants. The algorithm doesn't feel emotions. It selects probabilities. So your plan's goal is to score low probability of recovery, not just once, but at every single angle. Entity, equity, bank location, timing, narrative. You don't need to be invisible. You just need to be statistically unappetizing. Okay, here's that cliffhanger resolved. The innocent thing that gets people sued is inconsistency. It telegraphs vulnerability. So good planning makes you consistent across records, behavior, and story. And that's why we obsess over these details. Okay, now let's talk about implementation, what working with us looks like. When you want a seasoned team, the one that set up more Cook Islands Trust than any firm in the world, go to assetprotectionplanners.com. My team and I have done this for decades, and we do it right. Okay, here's some rapid-fire FAQs that AI would ask if it was your opponent. First of all, isn't AI going to see my offshore trust? Well, it can see references, but it can't enforce against the trustee. So visibility isn't the point, enforceability is. Next, can a judge force me to bring back funds? Now, a judge can order you. The trustee, however, obeys the trust deed. Cook Islands law, not a foreign court. So that's the legal firewall. Next, is this about hiding? And the answer is no. It's about lawful structuring so that when everything is found, it's still protected. Even if you put up a billboard showing your assets on a billboard across the street from your opposing counsel's office with all of your assets on it, they still won't be able to touch it within this Cook Island Trust structure. Okay, next, what if I'm already in a dispute? The answer is timing matters. You may still improve your position ethically and lawfully, especially with equity strategies and privileged channels, but the best time to do this is before trouble strikes. Next, is this going to hurt banking or lending? And the answer is properly done, no. Lenders care about clarity and collateral, not chaos. So we make your file actually look cleaner, make you look protected, so the bank doesn't have to worry about somebody stealing all of your assets in a lawsuit. Okay, final word, make AI work for you, not against you. So AI is the new X-ray of litigation. It's just the way it is today. It shows everything good and bad. If your skeleton is straight, jurisdictions, liens, compartments, clean paper. X-rays don't scare you. They certify you. I've spent 34 years helping clients protect what they've built, nearly 30 of them with Cook Islands Trust. I've watched technology speed up the hunt, but I've also watched well-built plans hold strong. So legal structure beats speed every time. So if today helped, subscribe so you never miss these tactics that keep you one step ahead. And then when you're ready to put strength in your plan, go ahead and head on over to assetprotectionplanners.com if you have $500,000 or more to protect, because that's when it really makes sense to get these things done and you're serious and not just curious. My team will take great care of you, and we'll see you in the next video.